I go first, 10 minutes, and then. Okay. Who will say something?
Not so brief. Sí. Claro. Bueno, claro, salvo que haya cosas. Yo creo que sí. ¿Ah? Lo recibí. Vale, yo modero la... Tiempos no tanto, ¿no? No hay que ser tan estricta con los tiempos, ¿no? Yeah, it's okay.
No.
I will say Fernando 5. So he can talk 15. Yeah, 10. Okay. We have time. Yes, yeah. I know. Okay. ¿Cómo está? ¿Ah? No. Buenas tardes. Bueno, ¿qué quiere? Nos avisa para que sacamos bonito. Well then, good afternoon to everybody. We will now start our seminar on legal rights with our guest professor, Liam Murphy, and with our commentator, discussant, Fernando Atria. I will first present Professor Murphy, and then I will give him the floor for around 10-15 minutes. Then I will say a few words, and I will pass the floor to Fernando, that will have 10 to 15 minutes to do his comments. After that, maybe Professor Murphy would like to have a few minutes to reply, and we will open at the end the debate with everybody. So Liam Murphy is Herbert Peter Freund Professor of Law and Professor of Philosophy at New York University. He received his undergraduate and LLB degrees from the University of Melbourne, and then earned an MA and a PhD in philosophy from Columbia University in New York. He has received fellowships from the Society of Fellows in the Humanities at Columbia, the Society of Fellows at Harvard, and the National Humanities Center. He has served as associate editor and is now a member of the editorial board of Philosophy and Public Affairs. Murphy was vice dean of NYU Law School from 2007 to 2010. He researches legal, moral, and political philosophy, and also the application of these issues to law, legal institutions, and legal theory. The topic of his publications range from abstract questions of moral philosophy, for example, non-legislative justification, to concrete questions of legal and economic policy, for example, the myth of ownership, taxes, and justice. A central theme throughout Murphy's work is the legal, moral, and political theories cannot be developed independently of each other. They are, in fact, different dimensions of a single subject. The paper we will discuss today accounts for this. This linkage also appears clearly in his philosophy of law book, What Makes Law, which places the question of the concept of law in the context of a broader question of political theory. We will discuss this in the session on Thursday, December 5th. Thank you very much for being with us. For the Faculty of Law of University of Chile, it's a real pleasure and honor that you have made the time for these two conferences. And yeah, we are pleased of having you here, of reading you, and of hearing you in this conference. Thank you very much.
Thank you so much, Flavia. Thank you to Rocio for making this possible. And thanks in advance to both you, Flavia, and Fernando for your comments. It's a huge pleasure for me to be here. This paper was written for an anthology on the philosophy of rights, but it's part of a wider project. The wider project is concerned with the, to me, regrettable tendency in recent moral and political theory to treat the rules of justified, legal, and other conventional practices as having moral force. This is an attempt, in one way, to get a little deeper, philosophically speaking, into an ancient theme of mine that goes back to the book I wrote with Thomas Nagel on tax, which is that the central institutions of a market economy, namely property and contract, are conventional practices, and much harm is done to our public political discourse if we mistake their rules for moral rules. In a companion paper to this one, I discuss another Razian theme. The work of Joseph Raz is obviously central to this paper, central to the companion paper, which argues against the idea of moral normative powers, which is an innovation of Joseph Raz relevant to the broader project. Now, in this paper, where my concern is the moral status of legal rights, I think that's the main concern, I would say I have two main points. The first is that the conceptual dispute between the will theory and the interest theory of rights is just a misguided project. It's always seemed to me to be the case, and I'm not the only one to think so, but a deeper dive into the literature hardened my heart on this point. In part, my skepticism, and this will come out on Thursday for any of you kind enough to come to see me twice, is a general skepticism about conceptual stipulation in normative areas in legal, moral, and political theory. And that's what an answer to this question on the concept of rights would be, will theory or the interest theory. But it's also because this particular debate, the will theory versus the interest theory of rights, seems so oddly located between the conceptual and the normative, asking us to take a stand on what rights are that can significantly constrain what rights we can in principle have. Now, of course, I hasten to add, we have to have some working account of what we mean by a right for discussion to be fruitful. But here I think Hofeld's terminological clarification is sufficient. And in particular, I think leaving aside what the idea that powers or what he calls immunities might be rights, I think they're probably best not thought of as rights at all. The two different kinds of rights that he identifies, claim rights and the privileges, are clearly understood. The former correlating with duties in others, claim rights correlate with duties in others that are directed to us, and the latter, the privileges corresponding with a lack of duties on the part of the right holder. This clarification, useful though it is, tells us nothing about what can or could ground claims or privileges, or what their point or function is. Now, from reading some written remarks that Fernando was kind enough to share with me in advance, it seems that he thinks the will theory is clearly defeated in this debate by the interest theory. I've described it as kind of a standoff, and let's just drop it and not talk about it all. I agree with him that if I had to choose, I would choose the interest theory. It's slightly staggering to me that anyone would take, for example, Herbert Hart's fairly targeted reflections on private law rights, such as the rights of the parties to contracts, as being the source of a general theory of rights across the board. That just seems very strange. But I also remain unconvinced by the interest theory, just because it seems too substantive in a way that begs questions within moral theory that I think should be settled through normative argument rather than conceptual argument. I think it might be helpful, as I don't really say this in the paper, although I gesture at it, to bring this out, is to imagine what an interest theory of obligation would look like. We don't have competing conceptual theories of obligation. I mean, in some sense we do, obligation distinct from duty and so on and so forth, but they're not contentful in the way that the will theory and the interest theory are. What would an interest theory of obligation look like? If someone were to say, obligations are reasons to promote interests, the audience would say, well, you're just converting a substantive commitment to a kind of a welfarist theory of morality into a conceptual claim. It would be to try and defend welfarist consequentialist account of obligation by way of definition. And that's obviously not going to be a plausible thing to do. And I think we should have the same reaction to any substantive theory of rights. Now, it's a little ironic that I make this point to say you don't want to make a normative question into a definitional question, since Raz makes a point like that, and I discuss it in the paper, where he says that any conceptual account of rights which makes it impossible for utilitarians to recognize rights must be rejected, because it would be to win an argument by verbal stipulation. But and maybe we can come back to this in discussion, but that remark of Raz is very strange, because classical utilitarians were completely happy, proud of the fact that they couldn't accommodate rights. They thought rights were a bad thing, or at least nonsense, moral rights, that is. Bentham, of course, as anybody would have to, recognized legal rights. And this brings me to the second and more important point that I'm trying to make in the paper. The first one being, let's not talk about the will versus interest theory. The second one is that we can get into it by saying Raz's motivation for saying that any satisfactory account of rights must be compatible even with utilitarianism. I think, I'm fairly confident, I wish I could ask him, comes from his general views about law and morality. In his exchange with Hart on obligation, in a series of articles, is back and forth, Raz makes it plain that on his view, there are not two species of obligation, the legal and the moral. Whereas for Hart, of course, there were two species of obligation, the legal and the moral. And Raz sets himself hard against this. There can be different perspectives on the law, so that you can have a committed perspective or a detached perspective. But if you have the committed perspective, that's the perspective of someone who accepts the law rather than just describes it. To say there is a legal obligation is just to say that there's an obligation, and an obligation will be a moral obligation. I think he has the same view about rights. A fully justified legal right will, in virtue of being fully justified, be a moral right. My paper argues against this view. And Judith Thompson, in her book, The Realm of Rights, makes the same argument, completely independently of Raz. I agree with Bentham, by contrast, that it's perfectly coherent to say that while there are legal rights, the law is full of rights, there's no such thing as a moral right. That's perfectly coherent. I don't believe that that's true. I do think there's such a thing as a moral right, but I think that these are two different beasts. Some legal rights just enact natural moral rights that we have independently of law or of any conventions, so like a right, the basic rights to bodily integrity, not to be assaulted, and so on. And if the law picks up on those independently existing natural moral rights and enacts them into law, then that legal right is at the same time a moral right. But Raz and Thompson think that in addition to simply adopting independently existing moral rights, the law can, as it were, create moral rights. There can be legal rights that don't correspond to any right that would exist independently of law that are moral rights. So three main points in my argument against. I don't deny that the existence of a legal order, legal institutions, can create new ways of violating moral rights. So property and contract law can create new ways in which a moral right of reasonable reliance, which I'm inclined to think we have, a moral right of a reasonable reliance can be violated in new ways once we have these legal institutions of property and contract. They are new bases on which we can reasonably rely. So that's one way in which the existence of the legal order can change the ways in which our moral rights can be violated. In addition, the legal order may determine in more concrete form the content of an abstract moral right. That's the first point. Second point is, I want to really emphasize that we shouldn't think that the fact that a legal right is morally justified as a legal right, what do I mean by that? That it's legitimate, that it would be okay for the state to enforce it, that it may even be appropriate for us to call others to account for violating it. All that would be a matter of the legitimacy of the legal right as a legal right. That's one thing. Another thing is whether that legal right is properly understood as a moral right with the full force of moral rights. This is just part of the broader point I mentioned at the start, namely the fact that a normative practice, legal or otherwise, is fully justified, beneficial, just, as a practice that is enforced by law, doesn't by itself show that its rules, the rules of that practice, should be understood as moral rules creating real rights and duties. Now, Raz, this is the third point, holds that if respect for a legal right is required by a moral duty to obey the law, the legal right thereby becomes a moral right. So if I'm bound by a general moral duty to obey the law, and the law tells me respect these legal property rights, that converts those legal property rights into moral rights. I argue against this by saying that a general duty to obey the law would be grounded in systemic interests or considerations of fairness, treating others as equals, whatever your theory of the duty to obey the law may be. These would be systemic considerations that apply to the whole scheme. These accounts of the duty to obey the law, speaking to system-wide concerns, don't speak, as moral rights speak, to the claims of the right holder. So if you say you shouldn't assault somebody, the explanation for that would lie in the claim of the right holder against being assaulted in this way. The duty to obey the law does not stem from the claims of the individual right holder. It stems from systemic considerations having to do with the system as a whole. So that's my argument, that these general duty to obey the law arguments that turn on systemic considerations cannot, by some kind of moral magic, transform legal rights into moral rights. I don't consider more individualistic accounts of the duty to obey the law. Perhaps we'll come to that in discussion, but I think I will stop there.
Thank you very much, Professor Murphy. I will say a few words on the paper, introductory words on the paper, and then I will give the floor to Fernando. Professor Murphy's text addresses the classic and important question about the nature and normative force of legal rights and defends the thesis, which I found correct, that legal rights are distinct from moral rights. Of course, this does not exclude the case that a legal right can contingently also be a moral right. As we all can understand, this debate connects with core questions of legal theory, such as what is law, what are the conditions of existence of law or of norms, how do we identify the law, is there a necessary relationship between law and morality, what types of norms do we find in a legal systems, are legal norms genuine, real, or authentic norms, or are they part of a broader and single normative system, say morality? What are the various subjective positions the norms confer on individuals, and what are the moral extra-legal foundations of norms? The thesis, as mentioned, is that legal rights are distinct from moral rights, that legal rights are authentic or fully justified legal rights on their own and without connecting them in any way with moral rights. This means that the nature of legal rights says little or nothing about the nature of moral rights, just as the normative force of moral rights says little or nothing about the normative force of legal rights. As he puts it, there is no necessary normative relation between the two at all. This position, as he has already said, is closer to Bentham and Hart and opposed to Russ and Thompson's. To support this thesis, Professor Murphy uses different theoretical frameworks, I would say. The first one is Hoffeld's explanatory model regarding the different types of rights and duties conferred by legal norms and the different fundamental neural relations they establish of correlation and of opposition, and how the law structures relationships between people. This is a known scheme that distinguishes, as he had already said, between Lucy's uses of right and duty. Concerning right, Hoffeld distinguishes among rights in strict sense or claims, privileges or liberty permissions, powers, competence, capacity, ability, and immunity. In turn, the term duty is used to denote duty in a strict sense or obligation, no right or no claim, liability, and disability. He analyzes, Hoffeld, dual relations among them, no? 4 relations of correlativity and 4 relations of opposition. I think this is a framework useful for showing that powers and immunities have no moral analog, and this is said by Professor Murphy in his paper, and for arguing concerning that the claims and the privileges, even if they do have moral analog, they in fact, the fact that there is a legal right, even a legitimately enacted, morally justified one, is itself entails nothing about moral rights. Then he uses this moral substantive theories framework concerning legal rights, namely the theories of interest and will, which actually inquire into the extra legal foundations for granting subjective legal rights. It argues about the object of protection, will or interest, and not concerning the means of protection. That would be these subjective legal positions, and he has already shown this is a framework that doesn't, it's not interest, it's not of interest or doesn't make a crucial point in Professor Murphy's argument. It's neutral, he says. It's neutral between the will and interest theories subjected to this theory of subjective rights. Then he briefly, but very briefly, I would say, uses the utilitarian versus deontological approach to moral rights. I think without very much development, but maybe there is he has said something now in his presentation, but I would ask if there would be a need of explaining more this approach. And lastly, he uses a distinction between what do we mean by moral force. moral force may mean that legally created rights have moral force where there is a moral argument to be made in that specific context that would explain the moral force of the legal right. Or by contrast, no, we could use it in another sense that Professor Murphy rejects, no, that legal rights have moral force when it is mean that there is a general duty to obey the law. And he says, concerning this last point, that there is no general duty to obey the law. And he makes also the distinction between a personal moral claim, no, and these systemic considerations such as democratic, social good, or fairness that would support this idea of general duty to obey the law. The clue question seems to be what makes a legal right, or what is the distinctiveness character of legal rights against moral rights, or what is the distinctive character of law? Murphy says that to be morally justified as a legal right, I take it that a legal right must be part of a legitimate legal order, where the standard of legitimacy will have both procedural and substantive elements. To say that a legal right is fully justified shows that its protection by the state would be legitimate, but it does not, without more, say anything at all about the moral significance of this right, legal right, for private individuals. So what makes a right a legal right then is, on the one hand, that the legal right must be part of a legal order, and on the other hand, that the legal order would be a legitimate one. Or to draw the whole chain, the existence of a legal right depends on the existence of a norm that conferred the legal right, and this norm must belong to the legal order. That is, it has to accomplish some kind of criteria of validity or of belonging, for example, created by a competent authority within the scope of its power and meeting the conditions of legal validity or the acceptance of social practice, etc. So I will point out a few more comments and then give the floor to Fernando. That legal rights are different from moral rights, and the fact that legal rights may not have a basis in a moral right depends on the thesis of the separation of law and morality, and on the previous definition of the law as an artificial product, no? Law as positive in the sense of being established by human will, the content of the right being determined by the will or a kind of agreement, no? In the sense that legal rights are, as Murphy says, creatures of law. This connects with the idea of acceptance of norms, with the fact that the members of the community treat legal rights as conferred by norms that, as norms, provide reasons for action and reasons for decision. Maybe it would be interesting to hear Professor Murphy about the thesis, the main thesis of legal positivism connected with the things that I have just said. So legal rights do not exist before the norms that confer them. The existence of norms is contingent and dependent on empirical circumstances or social facts. Professor Murphy then, I think, argues in favor of a non-reductionist approach to legal norms and legal rights. They are not reducible to facts, I would say, I'm not sure, nor to morality. A non-reductionist approach implies that there is no unity of norms or a single kind of normativity. It also implies that there is something distinctively legal, genuinely legal, and that legal norms are reasons for action different from moral reasons. Would it be useful for your thesis to distinguish among regulative and constitutive legal norms? This is a question. So futures inherently legal, unique to law, which would be these features inherently legal or unique to law? For example, authority and sovereignty, coercive power, legitimacy and validity, or to put it in McCormick's traditional way, no, the idea of institutional and coercive normative order. But we also have shared features with a moral normative system, like the fact that they are both rule-based in nature, or that they may have some kind of social function, or that they may also have some systematic structure. So these are all like loose ideas that your paper has provoked me, and I would be very glad if you can maybe say something about them. So now we will give the floor to Fernando Adria. Fernando Adria is PhD in University of Edinburgh, and he's professor of law in this faculty of law. So Fernando, you have your 10, 15 minutes.
I see that you have very little faith but you might be justified. Well, thank you very much for the opportunity to discuss this with Professor Murphy, and of course with Flavia, with Professor Carbonell. So thank you for the invitation, particularly to Rocio. Let's go straight to it. I must say, I find particularly refreshing the idea with which Murphy begins his paper that turns around the discussion between law and morality, at least at the beginning. I don't know whether you stick to it in the whole paper, but at least at the beginning, he says the notion of rights is a notion that is, so to speak, natively legal, right? It's not a moral notion. It was, to use a common metaphor used by comparativist lawyers, it was transplanted to morality, but in its origins, it's legal. And there is an interesting question here, because one of the peculiar features of rights, legal rights, have to do, or some of those features have to do with the institutionalized nature of legal systems. And that institutionalized nature of legal system is something that is particularly distinct from morality. So to speak about moral rights without further ado is to assume that that institutional nature of law is basically irrelevant when it comes to rights. And so the idea that the discussion of the relation between law and morality at least has a new perspective, a different perspective that is common. Usually, that is a discussion about whether this contingent normative order we call law complies with the requirements of this non-contingent normative order we call morality. But it is at least as interesting as that. I would say more, but at least as interesting to question the ways in which we think about morality are informed by legal notions like rights. And one of the dimensions in which I will comment the two main points of the paper as Murphy explained them to be. One, this thing about the will and interest theories, and second, the question of moral rights and moral and legal rights. The discussion of the will and interest theories, about theories of rights, it's one of those areas in which this is relevant, the fact that we are talking about notions that are natively legal. Now, as he has already explained, Murphy believes that this is a discussion that has lost, if he had it at all, any relevance. That is, as he says, important only for those directly engaged in the discussion, while the rest is left, he says, wondering why would anyone have thought the issue was important in the first place. Right. Now, I tend to agree that the question of the will or interest theories when it comes to moral rights is not relevant, but it is relevant in a legal sense. In my view, I mean, he presents the situation, as he said, as if we're a kind of standoff, right? So there's a tie between will theories that can explain some things, like, for example, or that can score some points against the interest theory, and interest theories that can score some points, and the match is a draw. Will theories have problems with inalienable rights protected by Bill of Rights, and also with the rights of children. And there is a famous article by Neil McCormick about that, and others who lack legal capacity, while interest theories have problems with third-party beneficiaries to contracts and to cases where rights justification seems to turn more on the interest of others than of the right holder. That I believe, as I said, that this standoff is artificial. The points scored by one side are considerably more significant than the other. This is because, in my view, the interest theory can explain better than the interest theory not only those cases that are difficult for the will theory, but also why the will but also what the will theory is usually credited with explaining, i.e., the relevance of the will in some rights and the problem the will theory faces. Between them, therefore, there is an asymmetry. The interest theory can explain the will theory, but the will theory cannot explain the interest theory. And this is a longer argument, but I want to put just one example when it comes to the rights of children or people who are not able to exercise those rights, and what Hart said famously about them. In a second moment, in a first moment, Hart said remarkably that we shouldn't be extending to animals and babies, whom it is wrong to ill-treat, of course, the notion of a right to proper treatment. For the moral situation can be simply and adequately described here by saying that it is wrong or that we ought not to ill-treat them, or in the philosopher's general sense of duty, that we have a duty not to ill-treat them. So there can be a duty, but we don't have any need to say that babies or animals have rights. This is Hart's first attempt. In the second attempt, he said, where infants or other persons not sui juris have rights, such power and the correlative obligations are exercised on their behalf by the appointed representatives, and their exercise may be subject to approval by a court. But since A, what such representatives can and cannot do by way of exercise of such power is determined by what those whom they represent could have done if sui juris, and B, when the latter becomes sui juris, they can exercise those powers without any transfer of fresh assignment, the powers are regarded as belonging throughout to them and not to their representatives, though they are only exercisable by the latter during the period of disability. So when we have a tutor and a pupil, for example, the powers are the tutor's powers. And Hart says, but this doesn't mean that the right is the tutor. The rights are those of the pupil. Why? Because of two reasons. One, because what the tutor must do is determine by what the pupil he represents could have done if the pupil were sui juris, and second, because the pupil those rights would revert to the pupil when the pupil comes of age. Now, in my view, here Hart is reasoning with a logic of a proto-interest theory. I mean, even though Hart is credited of being the main or one of the main representatives of the will theory, when it comes to explain the legal situation of representation, he has to look at interests. And because the key question here is, what is the meaning of this could have done criterion? Notice the idea is the duty of the representative is to do what the represented could have done if they were sui juris. But of course, it cannot be. We cannot take this at face value. I mean, the duty of the tutor of a 5-year-old child is not determined by what the 5-year-old child would have wanted to do. Of course, I mean, the whole point of representation is that the 5-year-old child doesn't know what is good for him. So this could have done criterion cannot be interpreted in a kind of naturalistic sense. And notice that this problem also appears in cases of rights where where the represented party is not going to come of age, like, for example, a corporation. You have a corporation and directors of those corporations. I mean, what the corporation could have done? Nothing. Corporations cannot do anything except by acting through representation. So the could have done criteria must be interpreted as pointing to the interest of the representative, the pupil or the corporation. The duty, and when we look at them, at this problem from the point of view of interest, everything becomes perfectly clear and reasonable, and something that is important for legal reasoning. The pupil has the interest, the protected interest is the pupils, is the corporations, and the powers are granted to the tutor or to the board of trustees and so on. And because of that, because in these cases we have a fracture, what I would call a fracture right, so that the interest protected is protected through the granting of powers to some different person. Well, in that particular case, it is not the case what Hart says generally about rights. Hart says, usually the right holder is a small scale sovereign, meaning the right holder can decide how to deploy, so to speak, his or her right in order to achieve his or her interest. But when we have a fracture right, the right holder, the power holder, the tutor, the board of trustees, is not a small scale sovereign. And there are duties of diligence, duties of loyalty that the right holder, the power holder has. And this can be explained by an interest theory. And this is not a detail. This is not something, a marginal case, like I would say, the case of third-party beneficiaries in contract. That is a problem, right? Because there they clash the idea of people being small-scale sovereigns as to how to advance their own interest and the privity of contract, of course. So concerning third-party beneficiaries in contracts, well, we have different solutions granting more relevance to one point or the other in different legal systems and so on. But the nature of fiduciary duties and rights and representation, I mean, is something much, much more systemically important from the point of view of the reconstruction of, I don't know, private law, corporate law, and so on. And I would say this would be my answer. Why is this important? Why we cannot just simply say, well, anything we say has to be neutral between will and interest theories, because that is the notion of rights is a notion crucial to the reconstruction of the content of our legal system. It's not part of the, so to speak, conceptual nature of law. I mean, there might be legal systems that don't recognize rights. Michel Villet famously said that Roman law didn't have the notion of right, our notion of rights. So this is supposed to be, of course, this is, I mean, there has been some huge controversy of whether Michel Villet is right or not, but anyway, the idea, Villet's idea, is that rights is a legal modern notion. So it's not necessary conceptually to describe the law, but it's necessary to describe our modern liberal law. And in order to describe it, we have to have a criterion that allows us to identify a right. And that is the question answered by the will, I mean, in different ways by the will and the interest theories. Do we have constitutional rights? The will theory will have to say no, because we don't have the corresponding powers. We cannot waive them. Anyone can claim in court, at least in Chile. Anyone can go in court and protect my right or anybody's rights, because those rights are rights of public concern. So the will theory would say, we have, I mean, that is, I mean, there are duties, of course, but in the legal sense, in the technical legal sense, there are no rights, no constitutional rights. I would say that consequence, maybe not when Hart wrote in the middle of the 20th century, because then it might have been reasonable to say the main notion of rights is rights as they exist in private law. But for us, I mean, the notion of constitutional rights, of human rights, is too central to the discourse of rights to say, to accept a theory that would force us, would saddle us with saying, well, there are no such things as constitutional rights. So I think, I mean, we cannot do without the notion of rights in order to reconstruct the content of our legal systems. And in order to use the notion of rights, I don't think Hoffel's taxonomy, useful as it is enough, precisely because we have to be able to have an answer to Hart's point. I mean, Hart said, well, babies don't have rights, though we have duties towards them. That was his first answer. I mean, that this is an important point about the one directionness of the correlativity of Hoffel's positions, to which we have to, I'll try to come back later. So this would be my first comment on this idea. And I was puzzled by this idea of Russ's, Murphy quotes, that any theory of rights has to be neutral in the sense that it cannot have as a conclusion that a theory like utilitarianism, as he explained it, cannot recognize rights. And not only for the reason he explained, that many utilitarians were proud of being able to do away with the notion of moral rights, but also because in Hart's view, that would be a way of winning by verbal legislation. But yeah, the odd thing in my view is, well, what's Russ generally doing then? I mean, if he describes one conclusion of his conceptual analysis as winning by verbal stipulation, well, one is forced to think that he would be presenting his theory. I mean, when he talks about the normal justification thesis and the authority, well, is he also offering us verbal stipulations? I suppose we cannot take too seriously that part. Or maybe he was very kind of strict, and he was saying issues of huge importance cannot be settled by theoretical theory, but theories can have other consequences. I don't know. I was thinking, for example, when Rawls said that utilitarianism didn't take seriously the distinction between persons, is it also about winning by verbal legislation of taking seriously distinctions and persons? I think that the discussion of what legal rights are is a substantive discussion about the best way to articulate, to rationally reconstruct the content of our legal systems. So that's the reason why I think it's an important discussion. And I think that after the emergence of the interest theory, the will theory cannot compete. Now, I'm already in the 15 minutes, but I want to say something about the question of moral and legal rights. I am not completely sure, but I said that cautiously, whether Russ would say that fully justified legal rights are necessarily fully moral rights. I mean, Russ says, for example, in this paper about human rights, some rights are created by law. Legally created rights may be moral rights. That is, they may be legal rights that have moral force. Others may lack moral force. For the rest of this chapter, he says, I will ignore legal rights with no moral force. I would say, I suppose that would accept the possibility that there are legal rights that are distinct from moral rights and have no moral consequences or moral force. And that would, in my view, would be kind of coherent with his idea of that when we speak legally, we speak from a legal point of view. I would assume that when we talk from the legal point of view, the question of whether this right has or has no moral force is basically irrelevant. Not because it is irrelevant, but because from the legal point of view, is not relevant. Anyway, I want to say something about Murphy's argument that general obligation to obey the law would not make legal rights moral, because that general obligation would not pick up so to speak, the direction of the duty, right? So the moral obligation might make moral a legal duty to FI, but it wouldn't pick up the fact that that duty is owed to the right holder, the legal right holder. So it would pick up the duty, but it wouldn't pick up the right. I mean, this is again interesting, an interesting point, because it points to the distinction between identifying a duty and identifying a right. I mean, his argument, as I understand it, is there might be moral duties then. I mean, there might be legal duties that become moral because of this general obligation, but that doesn't make those rights moral. And again, this would be also an illustration why just the Hoffel's taxonomy is not enough, because one would need a criterion to pass from duties to rights. Because as Kelsen said, the correlativity between rights and duties goes only one way. I mean, if Hoffel is right, and I think he is, every duty, every right, claim right, implies the correlative duty. But there is no reason to think that every duty implies a right, unless we want to dissolve the notion of rights into something that is basically, in my view, meaningless, of saying, for example, my duty to pay taxes is correlative to the Chilean society's right that I ought to pay taxes. But then the whole notion of rights become pointless, because rights point to individualized interest again. So duties that correlate to that kind of rights are not reasonable. I mean, that correlation the correlative shouldn't be taken that far. Now, I am not convinced by Murphy's argument about the fact that systemic considerations that would ground the general duty to obey the law would not pick up the right, also they would only pick up the duty, because I would say that the direction of the duty, the fact that the duty is owed to someone, is part of the content of the duty. I don't know where else would it be. I mean, part of the content of the duty is that of my duty to, I don't know, to act with due care towards others. I mean, it's a duty towards those others. And the duty that is picked up by morality, by this general, I mean, any kind of reasonable theory about a general obligation to obey the law, that argument would have to pick up the law with its content. I mean, the point of that general obligation is to make the legal content moral. It's to make morally obligatory the legal content. And part of the content of the duty is its direction. So in general, I would, the duty that is picked up as a duty that is owed to someone. Because, I mean, not because of conceptual considerations, because that's the content of the legal duty. If you go to the civil code, that's the legal duty you will find. You will find the duty of the seller to the buyer. I mean, you won't find a duty of the seller. You would find the duty the seller owes the buyer in virtue of the contract. And that is the duty that is picked up, that would be picked up by morality. A general obligation to obey the law would have to be, up to some extent, content independent. Of course, up to some extent. I mean, Thompson's argument, as described by Murphy, is not content independent at one level. No, first there is a kind of test. If the property system is not too unequal, then the property system is morally obligatory. So first we have a content-dependent criterion test, but if that content-dependent test is passed, then the whole system is picked up in a content-independent way. And I don't think that general duties, I mean, that kind of general obligation to obey the law that is at that level content-independent would be able to make legal rights moral because it would justify too little and it would justify too much. It would justify too little, and I will finish with this, because from the fact that the system fails to meet the general criterion, it does not follow that no moral value attaches to any right it creates. The fact that property is sufficiently unequally distributed, so there is no moral obligation to obey that law, for example, might render the general system illegitimate, might justify a revolution even, but that does necessarily imply that each and every property right the system creates is morally relevant. Wouldn't we say that the rich, at least in that system, have a moral duty not to steal from the poor? And of course, there might be moral, legal rights that are have moral force, even if the conditions for a general obligation to obey the law is not fulfilled. It justifies too much, because the fact that the system complies with the general criterion, assuming that property is sufficiently equally distributed, for example, will usually be compatible with some injustices. So, for example, a system in which property is sufficiently equally distributed might, however, allow for race-based restrictive covenants. Thus, the fact that property is sufficiently equally distributed implies that subjects have not only the legal but also the moral duty to respect those race-based restricted covenants. In my view, it's obvious. I mean, the answer must be no. So, a final word. So I'm sorry. I say I made a promise and I already broke it. But one final. Murphy recalls Dworkin's view, according to which law is just a sub-part of morality. He says, and I agree with him, that denies the reality of law as independent normative order, and for that reason is clearly mistaken. In my view, that idea of independence is critical for understanding what Dworkin himself called the point of law, though this is not what Dworkin said. We all live in societies which are more or less, but to a considerable degree, marked by what Rawls called the fact of disagreement. An important aspect of law's function is to provide an independent ground for the rules according to which we live together. Such independent ground implies that regardless of our disagreements, there can be a context of common reasoning, reasons that are common to all of us, in which there can be adjudication in Lon Fuller's sense as the decision of conflicts by reason and argument. Philosophers and legal theorists discuss the issue of the relation between law and morality as the question, as I said at the beginning, and this is why Murphy's perspective was refreshing in my view, as the question of the relation of these institutionalized contingent normative systems to that non-institutionalized, non-contingent normative system. This is what moral discussion looks like when it happens in academic seminars. But in reality, the question is considerably different. In reality, the question of law and morality is the question of whether law can provide an independent ground for the rules that bind us, or alternatively, those rules will always be what they ought to be according to the morality of the strongest. Thank you.
Thank you very much, Fernando. So now we will give some time to Professor Murphy to say some words about these comments, and then we will open the floor so you can raise your hand, and I'll start to take note of the people that is. Okay, if anybody wants to make the question in Spanish, Rocío is going to translate.
Relates to bigger picture on the relationship between them. Obviously, a conventional artificial social product. So there's Let me say a little bit about how strange those say is keep the bone walk at the end of his life. Other people, it's kind of the popular view of youngsters. This version is, which is what they call the one system view. One system, there isn't a distinct legal normative form. Basically, the legal rights obligations just are moral rights and obligations. Legislatures in the common law also. And I'm assuming that that's an incorrect view. That we can make sense of law as an artificial or conventional just games, normal orders, rules, orders, pattern, various conduct codes, and you look at the text and you see that there's an answer to the question what you can do and what you don't. And there are, I think it's an insight of parts that there are right and wrong answers to legal questions. That leaves it open what the moral normative force of the rights form and in classical law. He agreed with part about that. He just insisted that in order to get the content of the legal normative order right, you couldn't pretend that you weren't a moral agent yourself. You had to reflect on what would make the law as best that it could be. So, in some sense, it's all, I mean, it's a practice, but an instance of interpretation. Concept of law is, it's part of that practice, but the right answer is the one which makes the best. That's still compatible with the right answer being not the fully just answer, or the right answer not being fully compatible with morality. And I'm assuming that either the classical correct, and the one system says, when we're trying to answer legal questions, we're trying to figure out what morally we ought to do. That's wrong. Seems to me almost, it seems to be impossible to make that view compatible. Lawyers and judges think that. And so if you agree with me about that, then there is space that opens up for the idea that here is a valid in our positivistic or the non-positivistic sense of this is a valid right, but it's not a moral right. So it's the one system. It's all we're trying to do is figure out what moral rights we have. Some of them come from this institutional stuff, but that doesn't change their status as moral rights. That's the wrong way to look at it. But if you do look at things that way, this whole topic is making sense. So, there's so much here. Let me see. Just let me say two things. If you can't do without the notion of rights, still don't get why you think in legal rights. But I don't see why we need a theory like this to figure out what they are. I don't see why you think that the basic taxonomical isn't enough. If I said that what I'm writing is in the Bible. I didn't say that. I'm not sure they said that, but I flew through it. What I really mean to say is I don't want to have a theory of that kind, theory of what legal rights are in some sense beyond this idea that some of them are claims to correlate with people. Some of them are privileges, which means that the right holder has no. That's it. I don't see the need to tie it to something. And just specifically on the, I'll specify your emphasis on fractured rights, case of a true. That's where common law thinks about. If a fiduciary, a trustee, for example, as having a privilege, a right, for example, to use discretion in investing in trust property. It's for the benefit of the beneficiary of the property that's true. That's why they have the privilege. But they have the privilege. They have the discretion. So long as they comply with royalty. It seems like a more natural way of talking than to say that the person for whom the trustee has these get away from, right? That's the rights and so I'm still not convinced that role as the role of the real law. I talked about obeying the law can't directly make moral rights. Say, well, if you have a general duty to obey the law tells you that you have a direct duty not to violate the rights of this person. So that's a property right in question. So the law says, obey the law. So the law says, respect these property rights. Morality says, obey the law. Your suggestion is, well, morality is saying, now you have a direct duty because the legal duty is. See it that way. Clearly, morality is saying, obey this directed duty. From moral, that's the fundamental justification of following. So it doesn't, as it were, it remains purely superficial that I have a directed duty. Why should you do that from a moral point of view? If it's a real moral right, the answer will be because that person has a claim that correlates with the direct. That's not what morality is saying. Because you should obey the law. I don't really see how the direct is. There's much more to say than maybe.
Thank you very much. So we will open the discussion to the public. Anyone who wants to ask something? Yes? Wait, the microphone, please. Francisco Safi.
Well, thank you for the presentation and discussion. I haven't read the paper, but I was wondering. I was wondering on what you were saying before. How, because I tend to I agree with what you were saying mainly on the distinction between law and morality, but I was just trying to figure out how that argument connects. Maybe it doesn't, but that's why I wanted to ask you. But how does it connect with your argument in moral demands in non-ideal theory on the distinction between monism and dualism? So is there a sort of connection there? Because I always thought that there was a connection between moral duties and legal duties from the individual point of view in terms of what was demanded on terms of action as it applied morally to institutions, and then, I mean, it applied in the moral realm and in the institutional realm. So is there a connection between that argument and this one, or are two separate arguments?
Thanks. So if I understand the question, how does this discussion about legal and moral rights relate to the issue of we could put it as the normative significance for individuals of institutions. And I'm going to take the opportunity to answer this in a way that allows me to say something about a broader project. So I'm grateful to it. And I think you have picked up on something. In some sense, my overall interest at the moment is precisely what is the normative force for individuals of justified institutions or justified practices. And the Rawlsian position is something like this. We have a natural duty of justice. Natural duty of justice is support just institutions. And if they don't exist, well, do what you can so long as it doesn't cost too much to bring them about. Right? And I've always thought that was an unsatisfactory answer. He once had a different answer, which was in two concepts of rules, which was that if a practice is justified, then as a participant, you just follow the rules of the practice. You don't have to think about anything. And that's unsatisfactory because you want to answer the question, so why should I participate in this practice? Utilitarians give an answer. You should participate in the practice because the practice does good. But that's not a very good answer either, because it's not always for the best to follow the norms of the practice. Sometimes you do better from the utilitarian point of view if you don't. So I think, and a further answer, and the one that I'm sort of attacking in this paper and in the companion piece on normative powers, is that fully justified, especially legal practices, take on the rules of those practices, take on the status of moral rules. So there you go. You know, this just what you morally ought to do is to comply. And I don't believe that. So future work is there a better answer out there? So let me just repeat it. And so you mentioned monism and dualism. That was just the position I took, that it can't be the case that if take the view that Rawls does, that justice is about correctly designing institutions for the basic structure of society, that leaves individuals nothing to do on their own. I do believe that. But I also believe that the most important thing we can do is get our institutions right. But it also that leaves open the question, exactly what is an individual to think about the ethical responsibilities they have in respect of these justified institutions. Institutions don't operate on their own. They need to be supported by individuals. But what's the nature of the moral claim on the individuals? It's not, I think, that the fully justified institutions contain, because they're fully justified, moral rights and duties. That's what I'm arguing against here. And it's not the other things. But I haven't yet got an answer to that. I mean, it's going to be along the lines of some kind of imperfect duty of something like that, leading more in a less deontological direction. But that's
Sorry, can I just say something very, because I think that's actually, because you mentioned before presenting the paper your work on taxation, and I think that is something, what you were saying at the end is precisely what you do in book with Nagel, because in that book, it's funny how you build up the duty to pay taxes, not as something that actually has particular principles or particular rules that explain or justify the duty to pay taxes, but put it in a bigger frame of a duty, so to say, to respond to an idea of distributed justice. So in those terms, that's why it makes some noise, the argument that you were presenting now, in terms that you say there are legal rights that are justified within this conventional sort of understanding of the law that has some moral implications. But do those moral implications affect duties? That would be my question.
Well, I think that they do, but exactly how they do, it remains my sort of main research interest at this point. They don't in the way that I'm arguing Raz and Thompson thinks they do, by suddenly magically becoming moral rights and duty. I just can't believe that. I don't think, for example, that, just to give a very simple example, the main example interests me, the fact that we could have a fully justified system of property rights, that ought to be, let's assume it's embedded in a just overall basic structure, whatever, it ought to be supported as a system. It doesn't mean that those legal property rights are moral property rights. That would be one answer to the problem that we face, but it's not an answer I accept.
Thank you very much. Is there anybody? Okay, we have 3 questions here. Please, the end.
Thank you. Thank you for your talk and for sharing the paper. I have 2 questions. Well, my name is Antonio. I am still a PhD student at King's College London. I'm waiting for the Viva, so I will try to not talk too much because all the alone time. I have 2 questions about your paper, and the first one is more methodological, and is about, so is this doubt about the phrase of Russ regarding that winning by verbal legislation. So that is at the very beginning of the chapter of rights in the morality of freedom, and he's concerned with the idea of starting with the definition, excluding everybody else. And I have the same feeling that, or gives me a similar feeling, the problem with the Hoffel's structure or framework of rights. And Russ is explicitly against the Hoffelian framework. He claims that doesn't work. So if you think there is a problem, and I know this is the standard in the literature of rights, everyone see Russ through the Hoffelian lenses, so it's just normal, but maybe there is some place to advance, some little gap to go through, trying not to use Hoffel. Maybe this is not possible in the continental discussion, in the Anglo and analytical discussion. And the second question, you already answered one part, is if the problem with the moral and legal rights is not the source, and if not the source is Russ could be saying that the concept is the same, even though some rights have different content, and even though the source is different. There is a typical, very known, of course you probably know part of Russ, he says that the universalist fallacy and the individualist fallacy about rights, and the universalist fallacy is the belief that all rights derive from a bigger and unchangeable right. So he's not in that side. So he's not trying to mirror legal with moral rights. And so maybe the problem is more in the moral obligation to obey the law. And then maybe it helps this idea that some natural law theories make of distinguishing between the title and the content of the right, or the title and the measurement of the right. So the title can be positive or natural, and the measurement can be positive or natural. So that leaves a space for the full independence of legal rights, but also explains the deep connections that are conceptually, but also substantive between the two domains. So I think no RAS nor a natural theorist lawyer, will disagree that there is a specific legal or positive domain, but there is some connection. So my question, is to like how to explain not only the separation, but the connection between. Sorry for
say RAS rejected Hopewell rights. To me, that likely connect Hopewell thinks that powers, what he calls powers, are not rights. So powers are very important for understanding rights. They are not themselves rights. Same way, the lack of a power in somebody else. But I don't think the distinction between rights and privileges saying that. I think, I said this at the beginning of the paper, this bizarre tendency for analytic philosophers writing about rights. I think that Hopewell has identified 4 kinds of rights when he said no such thing. In fact, he was adamantly against it. He was identifying what he called dual relations. Dual because he wanted to include legal and equitable distinction for the common law world. But, really, it's legal relations. We're not and it seems plausible to use the word right for claim rights and privileges. But I may be not remember. The second question, I'm not sure that I fully got it, but it's true, and this relates to the incredible difficulty to interpret Rass's philosophy as a whole. Because we will remember that he's a hardcore legal positivist. So it's clearly the case for Rass that there's a sense in which you can identify a legal right, but he's open entirely moral standard of that thing. The paper that goes into how all this fits together is a paper with it's incredibly subtle, but it's something like this. There are layers of justification. So there's an initial identification of picking up what's called the positive domain, the sort of positivity aspect of it. So there's an initial identification, this is part of the positive law, but it's not going to be fully justified until it becomes something that rises to the level of a moral right for some reason or another. So I do think he thinks that there's a distinction in part of the law satisfying an initial validity test and being fully justified, and in his view, fully justified legal obligations, fully justified legal rights, just are obligations and rights. There's only one kind, and that's the moral kind. That's the way I'm reading the couple of paragraphs in legal rights, which has at least 3 or 4 different types of justification. Justification is very.
Thank you. Then we have another question, Johan, and then the lady at the back. Okay.
Okay, thank you so much for your presentation and your discussion. I am Svenja. I am has been recently accepted to the PhD program here in the University of Chile. I am a Chilean lawyer and a German lawyer, so I have lots of influence I'm influenced by Radbruch, of course, and about the theory about legal and moral rights. And I totally agree that legal rights are not don't have to be moral rights, but at the same time, of course, my education says as well that there are duties as well to pursue legally rights that are morally complicated or not law at all, like Radbruch said about the Nazi laws. So that's my little bit the problem as well with the moral force. It's a moral thing. It's a moral right just because they obey the law. But I think this discussion is no. So I just wanted to have this make this comment. Thank you.
Thanks. The Radbruch view, I think, is a species of what I'm calling non-positivism, and I think it's completely compatible with the analysis that I give, because he doesn't believe that the fact that something is a legal right makes it a moral right. He has a view about gross injustice disqualifying something that appears in the legal materials from being part of the law at all. And in that sense, morality is involved in legal interpretation, just as it is for the classical position of law. I actually think Walken, if you understand it correctly, he has a Radbruchian side to him, because he has to exclude material from the interpretation that just couldn't possibly lead direction. So I think that the Radbruch position is totally compatible with because he does not, like the late end of career Walken, and appears in his last, well, appears in a book called Justice and Robes, so tentatively, and he embraces that in his final book, Justice for Hedgehogs. The idea there's no sense to something being a legal right or obligation as distinct from it being a moral right or obligation. That no gap between the two. It's not part of his earlier view, it's not part of Radbruch's view, it's clearly not part of the positivist view.
Thank you. So we have, I think, a last question. Is anybody else? Okay.
Yes, thank you very much. My name is Johan. I'm a doctoral student from Lund University, Sweden, visiting Universidad de Chile this semester. So I haven't read the paper, but I found the discussion very interesting, and I had two reflections. So first, relating to this sufficiency of the Hoffieldian framework of rights. So Kelsen has an argument against the interest theory, where he says, of course, we can say that a duty leads to interest or a right for someone, but why do we need two concepts? Why do we need the duty and the right? Isn't the duty enough? So that would be his argument against the interest theory, but it's also an argument against Hofeld in a way. Why do we need claim rights if we have duties, and aren't duties more important? And then I've been thinking about this, and I think that when we interpret that law, I mean, law is always in motion in a way. And sometimes when it's a lot of interpretation needed, we need some idea of who has the right. And I think that's where this interest theory can be useful, when we have to interpret the law, and we have to say, okay, it's a bit unclear what this obligation or duty entails, but if we know what kind of rights it protects or what kind of interests, then perhaps these theories have some point after all. So I was wondering if you have any comment to that. And then I have another kind of general reflection relating to RAS and a lot of this Anglo-American legal theory, because often when I read it, coming from a civil law system, I find the discussion a bit strange, because it's so much about how you can predict the behavior of judges, and in common law, judges have a lot of discretion and they tend to use that power. So do you think that common law and civil law needs the same theory of right or theory of law, or maybe we need, different theories? So that was the second reflection. Thank you.
On the second one, funny thing is whenever I offer remarks along the lines of civilians probably don't have this problem because this is a common law problem, and I normally get like we have exactly the same problem, So, but this is just my ignorance about the law. But it's true that in the common law world too, exactly what the role of judges is contested. I mean, there are still common law propagandists who say, of course, judges don't make the law; they just discover it in the ongoing historical development of reason and so on. And law can actually, one way of understanding the motivation for the law, legal philosophy, is that you thought if the common law was a system wherein judges made law, it wouldn't be legitimate. And so you had to come up with a theory where they weren't making law, they were just discovering it. And the only way to come up with a theory like that is to say everything that we're doing as good judges in adjudicating a decision will be understood as finding the law rather than making the law. So that's kind of two different responses on law and civil law. On duties and claims, I mean, I think it is important that some duties correlate with claims and some duties don't. One way to bring that out is to say some duties, the duties that correlate with the right, you could do it a different way. You could say there are different kinds of duties. There are directed duties and non-directed duties. Maybe you wouldn't lose anything. I think it's very difficult for a lawyer to talk about the way the legal materials are structured without the notion of a right, because that's how they're written. But yeah, I guess you could rewrite them, but it's not just one kind of duty. There's three that tells us about that. There are very significant differences between a duty that's not directed at a particular person, like a duty not to pollute or to reduce your carbon emissions. It's a different kind of duty from a duty not to assault somebody. It has to do with like the directed duty does suggest this kind of relationship between individual victim and the moral agent, but the other doesn't. One way to bring this out on me is some of the discussion by Thomas Nagel about relativity and psychology and
chip in right there. Just a minute. But the example, one of the examples you discuss of duties that are directed is a duty that looks like the duty not to pollute, which is the duty not to take my garbage other days than Wednesday. I mean, this is Thompson examples, right? But I would say, why would that be thought of as giving me a right? Do I have the right that my neighbor not take their garbage other than Wednesday?
So just to clarify, Thompson's claimed right is a right as against a neighbor, that the neighbor not put his bins on the property.
Other than Wednesday.
Other than Wednesday.
Because I assume there is a kind of city regulation that says that garbage ought to be disposed in such and so in those places at those times, right?
Yes.
But that is like a duty not to pollute.
Well,
unless you want to talk about the neighbor's interest.
I think her intuition is if the garbage bin is out there on Tuesday, that gives her point against her neighbor. It's Tuesday. I only have to enjoy your bins in front of my property on Wednesday. You have violated my right. Like that seems perfectly reasonable to me.
But what if
I
it,
have a legal right? It's the idea that it's a moral right.
but what about is the rule if you cannot park in front of my property? Do I have a right that you not park in front of my property? I mean, it's just a duty. The fact that it's in front of my duty, why would that make it directed? The fact that it is in front of my property, I'm sorry.
Why is it directed to her? There's some sort of background right that she has as a property owner against people leaving stuff in front of her property. Parking, I agree, is different. It's so focused on the interest of the property holder.
The interest. No, I mean, that's the thing. I mean, you need the interest theory would provide you with a criteria. You would say this duty is justified, legally justified, or is rational. It's can be incorporated in a rational reconstruction by pointing to the interest of this particular person. That would make the duty a directed duty.
Yes, the way I see it, I guess it would be enough for her to say that she has a right. Is that something in the local ordinances in Cambridge, Massachusetts, which says persons may not leave their property in front of other people's houses, except subject to the garbage ordinance. It would have to, and then that she has a right is just found in the ordinance. That'd be enough.
Right. I'm not convinced, but fair enough.
Okay, I think we have a last question from Rocio. And then anybody else? No? Okay.
Thank you, Liam, Fernando, and Flavia. I have many different questions, but I want to make a question about the one part that Liam and Fernando seem to agree, the refreshing part, because I'm not first convinced, like as a fact of history, that the idea of right comes from legal thought, and I mean that morality borrowed from legal right. I'm not so sure because, and I'm not an expert on this, but I don't see Roman law having a structure of rights as we are discussing here today. Maybe powers, axio, like things you can enforce, but not. When the idea of rights started, it starts a lot from canonic law and natural law, and there's like a lot of morality in there, I think. But but then when Fernando said something about modernity, I think that the idea of legal right, as we're discussing it here, is a very modern right, and it has a view of the individual, of who is the individual, how is the individual, how is his relation with the community, with the political, and that's all a moral story, I think, about individuals. And as the idea of a legal right looks today, like, and even if it's true that morality borrowed in the 17th century from legal thought, today it seems legality and legal rights are fully borrowing from morality all the time. So even if it's like at the beginning it was a transplant from legality to morality, today it seems that the idea of law is so moralized because of the human rights and constitutional rights and all of that, that I feel like to pretend that that legal rights actually is a legal thing and morality is borrowing from here, I think doesn't, I don't know if it's really relevant to the argument of the paper. It's kind of a nice thought, but I'm not fully convinced by it.
If it is nice.
No, but I mean, no, because it can create a sort of noise that, like, and I don't know if it's so, because then the whole conversation is about, this obsession that we now have with morality as being part of what a legal right is. And anyways, but that's just one thing. The other thought I had while I was reading the paper all the time, and I haven't been able to fully formulate it, but it's like there's this an analogous conversation in the criminal law about mala in se and mala prohibita that kept coming at me. And I know that you make this distinction between rights and duties. And so in the case of criminal law, it's only about duties. However, it's very clear in some authors that the distinction between mala prohibita and mala in se, it's one of degree. It's not like a fully, like there's something that's wrong before the law fully, and then there's something that's only a wrong because it's prohibited by the law. But there are some mala in se that have a stronger prohibitum than others, and then there's some mala prohibita that have a little bit of mala in se with them, and there's like this whole. People talk about crimes and they distinguish. Like there are some crimes that are fully mala prohibited, or others that are fully mala in se, and then there's a whole range of between. I don't know if that in any way could speak to the issue that you have with the situation where you have a legal obligation to obey, and then the question of whether the law of a just system creates or doesn't create a moral right. In criminal law, we seem to be perfectly happy to identify the distinction. But because we see it as a matter of degree, I don't know if that could sort of bring you and Fernando closer in that area, or if the idea of there being a certain degree could have any sense in this conversation. So it's not a fully formed idea, but I thought there's an analogy there worth exploring.
On the first point, I don't know. With this stuff, Brian, Tierney, and it's unbelievable, and
Delay.
it's this whole world out there, and it's very difficult for the outsider. But what I do think is pretty clear, although you can miss it. But the ancient Greeks, Plato and Aristotle didn't have an ocean. If the Grotius is the center of the world, so what happened in Plato and Aristotle obligation or duty. So our early modern world of rights will be formed by the time of growth. Social theory, the ontology, consequentialism, this is just options that have always been around, but in fact there's a history to it. I find it very interesting. But I think it's qualified to answer the question, where did it get going? The person I enjoyed reading the most but he agrees with you fully that it's not identified. So anyway, I just feel it's so important when you think about the impact Grotius had. What's fundamental, perfect rights, whole modern set of rights that's what he pulls off, but he didn't invent it. Just a fascinating. I don't know about this literature that it's talking about, so I'd love to look at it. So what would it mean to be a matter of because the way I understand it, got the legal says this is your duty. You don't need to identify whether it's Mara and say in order to know the distribution. That's a theorist's distinction rather than a lawyer's distinction. So where's the matter of degree?
The role of the distinction is it's a normative role for criminalization discussions, like what should we criminalize, what not, in a way, like mala in se are usually considered to be fully justified because there are like pre-political or pre-legal reasons to not do that. So that's one. I don't know. I don't have a view that this discussion is really important for anything. I'm just saying that it's there. So it could be just descriptive, like, oh yeah, there are some crimes that there are some practical issues in continental law, like at some point in the application of certain weird rules, but it's not relevant. But I think the discussion is relevant because in a way it reflects exactly the three different possibilities, that there is something that is a legal right that reflects a moral right, but this is only duties, right? And there is something that's a legal right, but does not necessarily, and then there is an in-between situation that are like certain duties that become morally relevant because the law has certain institutions in place, right? And so, I don't know, not
Property.
well, property crimes, yeah. So property crimes, some people think they are mala in se, where the prohibitum plays an important role, because the reason why you have a sort of a moral duty, it's because the system is in practice, right? Like the system of property. While there are other crimes, there are not very many, but there are like, I don't know, maybe tax could be pure mala prohibita that doesn't have
Buying dollars in the black market.
yeah, I don't know, like something that, or perhaps that belong to a system that is not fully justified. I don't know. But I'm just saying that there is this kind of divergence. And then you have, and then you can also distinguish crimes that are crimes because they're in the law, even if it's in an unjust system. And the question is like, do you have a duty to not do this, or yeah, what kind of, so that's what's just my point, that there is this similar distinction, and that there is some conversation about there being a degree of more clear, and it's not that, but I think the conversation is not about the degree of mala insaneness. It's not so much about there being a legal political obligation, but about the importance of the behavior, or like they're recognizing like a harm that is valid or something like that. But I don't think I have like a full-fledged count of that. But there is, well, DAF has this view that there's a spectrum from mala in se and mala prohibita. And then there's different like degrees of prohibitum that something can have. The extent to which the sort of the wrongfulness comes from it being a part of a certain legal arrangement, or it being something we owe to each other due to our like being members of the human race, just morality. So the more the duty is connected to the legal system, and the more the foundation of its wrongfulness is because of the value of the legal system, the more it is malum prohibitum, and then
Yeah, but that wouldn't be a distinction of degree. It would justify that there are three rather than two possibilities, right? So mala in se, like killing, I suppose. Mala prohibita, like paying taxes or something like that. And in the middle, something like respecting property. You wouldn't have property if it were not for because of legal rules. That would be the third stage, right?
Well, I guess, yeah, I mean, the degree thing for me, it's also helpful because I also think there are degrees of political, like a system could be more or less morally justified, and then the kind of the
More or less
the
obligatory.
yeah, so I don't know. Yeah, I have my red. I don't know why. Much. But maybe it's just three.
I'm not getting, tell me if I'm stop, but I'm not getting why tax and property would be different. Both both of them are the means to achieve certain kind of just social order that we have. Tax is purely for property mix. That because there's some sense of natural property rights floating around. Property crimes can harm people in a way that straightforwardly harm property rights. Well, I think Fernando in Britain, unjust legal order of unjust system of property. You could say that at least the rich should steal from the poor. It seems to me that could be explained.
Yeah, but you will still need some legal categories to say, to specify when those poor people are entitled to the resources they hold.
I'm not sure about that. I mean, I think that if equally the rich person who's a little bit faster than the poor person doesn't need the treasure that's there, they should let the poor person get it for the same reason. I mean,
but you will say that the fact that the poor came first wouldn't change the situation in any way.
Well, if you have legally protected property rights, then you'll have certain reasonable expectations that are different.
Yeah, tax is not a good example. No, buying dollars in the black market, because that assumes that just so to speak, a political decision that could, a policy decision that could change any day. That's forbidden. Tomorrow it might be allowed. That's different from tax and from property, I suppose.
Something that strikes me as plausible is that certain kinds of the legal order to survive and do what we want it to do is sort of central to the well functioning of the thing. But they are related to institutional structure. They wouldn't be there in say nature, as it were. And that seems to me say we do have moral things. But that might be read. Okay. So this is really helpful. So to say it's a moral doesn't mean it shouldn't be interpreted, and it's a duty we would have if we were in a state of nature. Many of our moral duties do relate to our own.
Okay, then we have had a very interesting seminar. So thank you all of you for attending. Thank you, Professor Murphy. Thank you, Professor Atria. Thank you, Rocio, for organizing this. And we will see you on Thursday. Thursday at 11 o'clock, we have the second seminar on what makes law. What makes law law? Okay, thank you very much.
I assume.